You know what time it is. Disclaimer, I am not an attorney, nor do I offer or give legal advice. So please understand that all information that we talk about in any of my webinars are strictly information and educational purposes. And most of it is just personal experiences with things anyway. So please understand this is not legal advice. And may you be blessed on your journey to find your power within these laws. Peace and blessings. Thank you for joining me. Today, I wanted to briefly go over my new website called the 3X Credit Accelerator. Now, for everybody that's been asking for courses and mentorships and, templates and things of that nature, I decided to create this website to give you a source to go to just in case you would like a little bit more further assistance in obtaining clarity in what's going on with our documents, as well as the way we deal with these fictitious entities based on someone else's prior experience. All right, so here we have ebooks. You're going to have courses as well as PDF documents that you can download from my website here. Now, when you go here, you will have to enroll as a student, okay? And once I do upload anything that's new, you will be notified and you will have access to that information. All right, so this will be a direct link to me and my information. So we're going to glance over this real quick. As you see, I have the ebook getting ready to drop on mortgage reconveyance. It's going to be called Reverse Overlay. And then I have the Credit Unlimited Blueprint for AAA credit rating that's available right now at $97 before it drops here in a few more days. Then we have the webinar from the mortgage reconveyance I did a few weeks ago, as well as a core and satisfaction course, an arbitration pro se course, warranty deed acceptance course. And we go right down here, we click the little button and go to the next tab. And we have mortgage reconveyance course. We have the TILA 2-time finesse webinar replay, as well as the TILA 2-time finesse course and the round robin cash out course. All right, so I just wanted to share that with you to let you know the website is up and available for those that did not know, and it is a 3X Credit Accelerator. Now, with that out of the way, let's go ahead and get on to what today's topic is going to be on. Now, I have been getting a lot of inbox messages about the statement of account and what do we do about when they don't respond, or they have failed to uphold the UCC. Well, that's what we're going to get into next, and I'm going to show you what I personally have done. All right, So here we go. Here we have pulled up my notice of dishonor for non-acceptance. In my previous video on the statement of account request, I showed you where we sent out them the private notice of their default. So with this document, we actually going to use this document to put something from the private into the public, where we're going to record it in the county. So we got to let the county understand what's going on so everybody can understand what's going on. All right, so here we go. Here we have it titled Notice to Agent is Notice to Principal. Notice to Principal is Notice to Agent. And of course, this is a maximum of law. Notice of dishonor for non-acceptance. Non-acceptance of what? 2, deed of trust, contract offer pursuant to the UCC 2-202 offered on January 25th, 2022. Certified mail number, loan number, this corporation. Now you notice the default notice was May 20th. So 3 days later, I'm recording this document. And once again, we are addressing the living in representation as the agent or principal of the fictitious corporation. At this address, they're titled as the beneficiary on the documents recorded. CC, the respondent, trustee who was nominated on that document as well. And here we go. Pursuant to UCC 2-202, final written expression. This notice of dishonor by non-acceptance is to inform you, Rick Smith, acting in a capacity as the CEO of Dominion Financial Services, LLC, company operating as a commercial enterprise, and all involved, that as of May 23rd, 2022, we have not been presented with, nor is there an authenticated, keyword guys, authenticated record of the acceptance, evidencing consideration of the contract offer titled Deed of Trust, Assignment of Rents, on file with the Henderson County in regards to the real property known at this address. Okay, we go down here to the statement of facts. In formation of the deed of trust and assignment of rents, the document recorded on file with the Henderson County, as well as the documents we received at and after closing, did not have an authenticated acceptance evidencing consideration of the contract offer bearing any signatures of the other parties involved, such as Jason Koresh Wise Esquire, named as the trustee, or the beneficiary mentioned as Dominion Financial Services LLC, nor were either of the two parties physically present at closing. Pursuant to Texas Business and Commerce Code 2.206.10a and UCC 2-206.1a states, unless otherwise unambiguously indicated by the language or circumstance, an offer to make contract shall be construed as inviting acceptance in any manner and by any medium reasonable in the circumstances. It also states in Texas Business and Commerce Code 2.2062 and the UCC 2-2062, where the beginning of a requested performance is a reasonable mode of acceptance, an offer or who is not notified of acceptance within a reasonable time may treat the offer as having lapsed before acceptance. Now, please take notice as the trustor. See, we are the trustor. We're not the borrower. We're the trustor of said deed of trust. We are putting you on notice of dishonor for non-acceptance of what, y'all? The contract offer that stated Jason Koresh Wise Esquire as a trustee in regards to the deed of trust and assignment of rents, recorded and dated on January 25th, 2022, recorded in Henderson County on the real property known at this address, for dishonor by non-acceptance of contract offer. Please also note that any and all power and or rights offered or presumed to Jason Koresh Wise Esquire as trustee, a fiduciary, and Dominion Financial Services LLC as beneficiary were and are null and void as of when? January 25th, 2022, for dishonor by non-acceptance of contract offer prior to it being recorded against the real property. An offer of conditional acceptance for a settlement was sent certified mail on March 1st, 2022, and tender of payment was registered mail, that's the registered mail number, to your servicing company at this address on March 2nd, 2022, from the Office of the Trust, the Secured Party, Dominus Litis Express Trust, for any and all lawful claims against the Stand Strong Investments at this address. And that offer was delivered on March 7th, 2022 at 11:58 a.m. for acceptance of full settlement of all claims of any obligations by way of chattel paper that could be presented as authenticated certified copy under the penalty of perjury. Okay, so I'm giving them notice of what's going on, and I'm time stamping everything that's transpired up until this point. So we remained in honor. We issued you payment and we gave you time to respond, and you still didn't. So we're just outlining these aspects and actions in this document. Payments in good faith and full final settlement of all claims owed via restrictive endorsements was also tendered, accepted, and cashed by your servicing company, Face Servicing, as drafts for full satisfaction via multiple postal money order drafts, which constitutes a full agreement by offer and acceptance by way of acquiescence pursuant to Texas Business and Commerce Code 3.311 and the UCC 3-311, titled what? Accord and Satisfaction. So I'm letting them know, hey, we completed accord of satisfaction on you as well. Then after that, I'm telling them what we did after that. An authenticated request regarding statement of account and regarding Texas Business and Commerce Code 9.210 and UCC 9-210 was sent and delivered via certified mail. This is the number on April 29th, 2022 at 2:56 p.m. as of May 23rd, 2022. And as mentioned in previous default notice. Yeah, see, we've already mentioned this in the prior default notice, so we're reiterating it and putting it in the public now as well. You have failed to comply pursuant to Texas Business and Commerce Code and the UCC law. Therefore, my statement of account remains as stated as a balance of 0. Okay? Now we go to the demand for settlement and remedy. Take notice, in the event there has been any invalid liens or encumbrances placed on the title of real property stated above as a typo, please provide authenticated documentation of the release of any and all liens and or encumbrances within 10 business days of receipt of this notice, stating that the title of said property is free and clear of any encumbrances from you or your associates, and the certified funds check issued with tracking in the name of Dominus Litis Express Trust, care of State Straw Investments LLC, for a refund of any and all payments tendered in full satisfaction of claim upon demand and lawful money, pursuant to 12 U.S.C. 411. Take further notice, if we are not able to settle this matter in the private by prompt receipt of authenticated documentation and certified draft for refund of payments and lawful money, the Office of the Trust is prepared to take further legal action for settlement. For your viewing pleasure, we have attached a fee schedule of our Office of the Trust. This notice has been authenticated by signature below. So boom, we are self-authenticating document right here. We sent that off, and boom, they have been served that document as well. Now I would like to show you a little bit more examples with some case laws that I put together to just show you why they have a duty to respond. And that's going to be the next part. Let's go to that, shall we? Me from jumping around from screen to screen, I just copy paste with hyperlinks and put them all in one document here. This document will also be available in my course. So let's get into it. Duty to respond case laws. Okay, here you see this is a hyperlink. So if we click on it, it's going to take you to the actual case law or source site information where I got this from. And I went on ahead and highlighted all the information I want you to focus on based on what's already been ruled. Okay, for our duty to respond, and let's read the first one, shall we? First one, all right. This is Western Insulation versus Central. I think that's National Insulation Company or something in that regard. Here we go. Mere silence ordinarily does not amount to an acceptance. However, if the relationship between the parties is such that an offeror is justified in expecting a reply, or the offeree is under a duty to respond, silence will be deemed an acceptance. All right, and as you see here, the trial court found a contract between Western and Metco for $250,000. This finding was adequately supported by the record before us. Okay, here we have Gupta versus Morgan Stanley Smith Barney LLC. Says, let's see what we are by applying state contract law, first option of Chicago Incorporated. Gupta argues that no arbitration agreement was formed for two reasons. First, he describes his failure to respond to the September 2nd email as silence, and argues that silence constitutes assent only if, quote, the offeror has stated or given the offeree reason to understand that the assent may be manifested by silence or inaction. Restatement second of contract says 69 Group contends that Morgan Stanley never gave him such a reason. All right, then we have another one here. I guess this is Gracie versus Lewis. All right, some cited case items is entitled to due regard in judging the credibility of the witness and will not be second guessed by this court. And that's C, Minneapolis, Civil, Ordinarily, mere silence does not amount to an acceptance. However, when the relationship between the parties is such that an offeror is justified in expecting a reply, or the offeree is under a duty to respond, silence will be deemed an acceptance. Okay, see Hope versus Sweden. Here we go. Here, appellates received the street access they desired, but only after respondent had agreed to dedicate land necessary to the bill, the whatever that was. All right, concrete versus butyl. All right, the defendant property owners did not object to the proposal, and the district court held them liable under an implied in fact contract. All right, we affirmed reasoning that although mere silence does not constitute acceptance, quote, when the relationship between the parties is such that an offeror is justified in expecting a reply, or the offeree is under a duty to respond, silence will be deemed an acceptance. All right. Similarly, if Douglas Butu did not wish to be obligated for the contract work, he has a duty to object after his discussion with Don about the couple's whatever work they were doing. All right. Now we have Cargill Incorporated versus Jurgensen Farms. Cited 31 times. Silence is sufficient evidence of the formation of a contract to avoid summary judgment, but ordinarily mere silence does not amount to an acceptance. All right, only when the relationship between the parties is such that an offeror is justified in expecting a reply, or the offeree is under a duty to respond, silence will be deemed an acceptance. Here, both parties deny the existence of an oral agreement, and Cargill has offered no evidence that, given its course of dealing with Jurgens Farms, silence on the part of the Jurgens Farms was, I guess, considered acceptance, right? Blallett versus Paris. All right, let's see. Ordinarily, mere silence does not amount to an acceptance. But when the relationships to a party is such that an offeror is justified in expecting a reply, or the offeree is under a duty to respond, silence will be deemed an acceptance. And this is what January 2006 letter, a respondent requested that appellant notify them of any rent increases for upcoming year by October 1st of the contract year, because the land is fertilized in the fall after. All right, so there you have it, my people. Here goes some case laws to support the understanding that when we send documents out to these people and we have some type of prior arrangement or agreement, they have a duty to respond to us. And by them not responding is tacit acquiescence. All right, they accept. All right, now let's see. I appreciate you all for staying tuned, and we'll go ahead and get on to the next video. See you next time.